All right. Here's the court because of the state. This is now in session.
Good morning, council. You may be seated. Person arguments as judges, so I'll that we all will be a little nervous, just as you are probably a little bit nervous. So, but we'll get through this together. I want to welcome everybody to the May 10th docket of the 2022 year of the Kansas Court of Appeals. My name is Amy Klein, and I'll be the presiding judge. With me, I have Judge Leslie Isherwood and Judge J.C. Hurst, who joined the court very recently after I did. We've all been on the court for about a year now. I'll go ahead and call the first case, which is number 124-199, the state of Kansas versus Alan Michael Hurst. Have the attorneys under their appearances?
Your Honor, may I please court Jessica Dash for the appellant, Alan Hurst, here and here and ready to argue.
I know what you mean.
Can't remember.
Thompson for the state and that building.
Thank you.
It has been 3 years since we've been here.
Well, like I said, we'll all muddle through this together. Let's get on the important stuff.
If I might ask, do you want the factual background since we're on Zoom or not?
You know, I do, and I was gonna, actually ask about that. I think just maybe a minute or so to kind of orient everybody. I won't start your time, but we are going to be streaming, and so it would be helpful to have some kind of a background for everybody of the case.
Just curious about that.
Yeah, and how much time did you want?
3.
Well, counsel, you may proceed if you're ready to go.
Thank you.
Everybody else ready?
May it please the court, I'm Joseph Dash. I represent the appellant Alan Hurst. First of all, his background, exactly 9 years ago today, Alan Hurst was serving the last few years of a prison sentence, a Kansas prison sentence in Lansing Correctional Facility. And he and another inmate, at least one more inmate, escaped in 2013. After the escape, Hurst and another inmate, Scott Gilbert, traveled to Platte County, Missouri, where other crimes were committed, resulting in a 20-year Missouri prison sentence for my client, half of which he's going to be required to serve due to the Missouri's magical parole system, which is confusing as Kansas sentencing guidelines. Let's see. Back in Kansas, he was charged with aggravated escape from custody due to breaking out of prison here. Let's see. And a couple other crimes related to the escape. Detainer was lodged in the state of Missouri immediately. After filing the proper documents under UMDDA, Uniform Mandatory Disposition of Detainers Act, which is a mouthful, he was returned to Kansas in 2018 to settle the charges. Shortly after he was returned, days later, he pled no contest to one count of aggravated escape. The other charges were dismissed. He was later sentenced to a 130-month prison term. He filed a timely notice of appeal on August 3rd, 2018, but his appeal was anything but timely. In this case, and
That's what leads us to.
yes,
That's what leads us to today.
that's what leads us today. Now, this is actually technically a direct appeal, but what we're talking about today is a speedy appeal. And some of the discussion within the briefing is, well, when does that speedy trial or when does the speedy appeal start? Whose fault was it that it was not speedy? And my client can always say, and has saying, hey, none of it's my fault. The judge appointed the ADO at the outset, about 6 days later after the appeal. And then the appeal wasn't docketed for 3 years. Now, there are different parts of that time period. First of which when the ADO was appointed and didn't do anything for 14 months, and then they moved to withdraw. Then for 13 months, the judge didn't appeal or didn't appoint anybody else. So the question is, where does the responsibility for that time fall? My client would say falls on anybody but me, because I was in prison and I couldn't do anything.
Mr. Dash.
Yes,
I
yes,
don't
sir.
want to interrupt. First, I would like to say, as funny as this is, Judge Hurst does not know Mr. Hurst, nor is she related to him. Hasn't he? I just thought we would get that out of the way right off the bat. It's a pretty
Certainly.
common last name. So let's assume that this court agrees with you and your client not at fault at all for the delay. And we agree that there's a delay,
Okay.
a long delay, long delay. Do you think that delay causes prejudice per se?
And that's the question.
So does prejudice per se exist from a long appellate delay? And if not, let's get into how your client has been prejudiced by this delay.
As a lawyer, I have to say, no, there's no prejudice per se. And the case that we all have to look at is Bussart, and I hope I say this right, but I probably won't. Bussart Savarloja, and they set out a four-point analysis, and we're going to skip down to prejudice at this point
Let's start there.
because I think that's fair. Well, his suggestions or his arguments at the district court were that he was prejudiced by the time because he had anxiety about what was going to happen when he got back to Kansas, because he had pending things going on in Missouri. He had a parole analysis to be done, which was affected by his detainer.
Can you tell me about that?
I can tell you about it. It's not in the briefing, but I researched it while I was getting ready for today's hearing. Missouri. Parole is based on three different items. First, it is something called salient factors, which I'm just going to pull out the thing if you don't mind.
I don't mind. That's fine.
Find it. I think I have it. I thought I had it. Maybe I don't. Okay, well, I'll have to do it by memory because I don't see it. Unless I'm just really fun. Oh, here it is. Here it is. Okay. The level of offense is primary. And he was charged with what you'd call the most serious offense, violent A, B, and C felony offenses in Missouri. So he goes on this chart, the S appendix, which is the highest appendix in their system. And that's a chart that basically says, it's kind of like sentencing guidelines. What's your crime? How have you behaved? The salient factors are how you behaved and what's your criminal history. Just like we'd have criminal history in the sentencing guidelines. But those factors, you get pluses and minuses and things like that. But one of them is, do you have pending cases? Have you served prison before? Do you have, let's see what else here. Okay. Other convictions, other incarcerations, 5 years or more incarceration free. Of course, he couldn't have that at all. Revocations of parole, current offense, is recidivist related to current age, institutional risk, educational attainment. I mean, it just goes on. And alcohol and drug, conduct violations per year for commitment, major conduct violations during commitment, and prison escape. Well, the prior escape, absolutely. He's going to have that. So his case not being settled, and whether you like it or not, case is not done until the direct appeal is complete. So we're still not done. His adjudication is not final, or it's not, his conviction is not adjudicated completely. So technically, he doesn't have anything yet. But could he? Most likely. Is that going to change the way he does things in prison in Missouri? Possibly. But he has 130 months sitting on his head, thinking about what he's going to do after he gets, or if he gets out of Missouri, or when he does. What I've determined, though, is he was already granted parole after a 10-year sentence of the 20. And so the point being, he's looking forward. He's looking forward to the Kansas thing, and he wants this to be over with, and it's not yet. So there is.
You mentioned that he had claimed he suffered some anxiety, and I know you mentioned that in the briefing as well. Is there anything in the record that documents any sort of medical treatment or prescription medication that he was given to address that anxiety?
I do not believe so. I think, and I could definitely say that came in that last hearing in volume 6. There's a big section in volume 6 where he is testifying about all of his anxiety. It really didn't come out in the pleadings so much as it did in the,
His testimony, there's no
it's simply his testimony.
medical records that were, I couldn't
That's
find
correct.
any offered as exhibits, and I wanted to make sure I wasn't missing something.
That is correct. But his testimony is basically all the things he tried to do to contact his trial court lawyer to what's going on with my appeal, because he didn't know who'd been appointed, because he didn't get notice of that. At least that I could tell. We don't even know if the ADO got notice, which is something's been an endemic problem lately. They don't get noticed and they don't look at things, and then they find out, oh, we're appointed. We have a conflict. Now, I would say, and we were beyond that point, so I'm not going to talk about that. I'm sorry.
Feel it's pertinent to your case, feel free to talk about it.
Well,
I just
I'm
wanted
sorry.
to address this point.
But the prejudice is the most important thing. And really, under Broussard, if I said that right. Lost my spot. Sorry. There is a magic language for that in Broussard. I'm going to find it real quickly.
So you're not asking this court to weigh the other factors more heavily than the prejudice factor or anything like that?
Well, I'm asking you to weigh them as Broussard requests you to. And I think that they're all 4 equally weighted, and some factors go more heavily towards him or the state, depending on the reason for the delay and et cetera. And whether reason for delay, the assertion of his rights, which he did 2 years later. And if you weigh in the assertions that he made before he actually did anything in court, you can consider that that goes in his favor. Let's see. And then you balance the 4 factors that there are with the prejudice. So it's an inordinate delay. It's absolutely that. Is there prejudice? That's a good question. And my arguments, I don't have a whole lot of ammunition there, because all I have is what he said his arguments were, or what his anxiety was, and uncertainty. Uncertainty and anxiety, there are certainly factors to be considered. Like I said, in Broussard, there's a particular language that talks about that, and I don't have it right in front of me, and I'm sorry.
That's all right, I think we're familiar.
But it's under the prejudice factor.
Can you tell me then the remedy?
And
I
that's,
would say that your briefing seemed to leave some of that up to our discretion.
that's the big question. What is the remedy? The district court, when it considered his case, said, I know this isn't right, but the remedy is not dismissal. I don't know. Is that really fair to dismiss the state's case when they've already made it and had it completed to their level? And then the problem is in the appeal process? I don't know. I wish I had something that would say that. None of the cases have described it, because none of the cases have actually found prejudice.
But dismissal seems to be a very extreme dismissal of a conviction
Mhm.
in a case that he entered a plea to correctly.
I completely agree. Yes.
That's not the road you're suggesting that we take.
I'm not sure what the right thing is, to be completely honest, because right now, the conviction's not final. I mean, it still isn't final. So is it an actual bona fide conviction at this point or not?
But if he entered a plea, he can't challenge his conviction on appeal. The only thing is to challenge his sentence on appeal.
I agree with you, Your Honor. And those challenges that I looked at that were attempted in the district court were not valid in this, that wouldn't have flown here. So.
And so we do have and I wanted to be clear on that, the appeal, there is a lack of a substantive
There is,
direct appeal issue
absolutely,
other than this procedural issue.
absolutely. I couldn't find any merit in the consecutive sentence argument, because you have to be consecutive to your sentence that you haven't served the rest of in Kansas. So saying Missouri is consecutive is not a problem, because you're not done with your first sentence that he escaped from. So, I mean, that's being straight up. If there's nothing further, I'm going to go ahead and sit down. I don't know how many minutes I'm through.
Oh,
but-
just 2, so you'd have 5 minutes remaining.
and I may not use those. Thank you.
You know,
I'm
before
sorry.
you stop though, I do want to say that we really appreciate your candor in all of the arguments in your briefing, as well as in your oral arguments. It makes our job so much easier and we can really get to the heart of the matter that much quicker. And so we much appreciate all the candor that you've shown in recognizing maybe some of the limitations that you've got in this case, but still making a good argument. So we do thank you for that.
Well, thank you. Thank you.
Mr. Thompson?
Please, the court.
Yep. Let me reset the
No,
clock
that's-
though. I think you want more than 2 minutes, right?
I don't know if I need more than 2 minutes.
You don't have to use it all. Once again, we would appreciate getting to the point where we don't mean to say that you have to use it all, but
No,
I
no.
certainly will give it to you.
As Mr. Desch said, the Bassart language kind of goes off of the Barker-Wingo logic of the 4 points to be looked at. I think the key point or the more salient point is the prejudice. We would argue that there was no prejudice, that he had a 25-month sentence that he still had to serve through the state. He had a 20-year sentence that he's still serving. As pointed out, he did not show any more stress or anxiety than what he kind of said he did, but there shouldn't be that there because he's still pending his sentence. It's not like he, as in the argument Bassart uses from a Harris language, there's a 3-part test to look at like if there's a prejudice to him. And I believe that was what Mr. Desch was kind of looking for, is whether he suffered some oppressive incarceration, which this wasn't because he was incarcerated for another count, and whether he was impaired on his appeal rights for this when he already pled. And as Mr. Desch has said, or Mr. Desch kind of conceded, there really is no other argument on his plea. So it's just whether the sentencing was some type of reason why he can't have or is oppressed by his defense by it taking so long. And so the only other issue is the one that Mr. Desch has kind of argued for Mr. Hurst, which is he suffered some type of anxiety. And the state, as it did in his motion, does not file that there would be any type of anxiety, because why would be so anxious about what he's facing when he's already still doing other time? He's just waiting for this time to be served. So whatever he might be concerned about should not be overwhelming with what he has to do. It's,
But certainly we can agree if you're stuck in jail and you don't have an attorney and you're trying to find who your attorney is, you don't know, you go for years and you're not hearing from anybody. I mean, that would cause somebody, I mean, it's fairly credible to assume that they're going to have some anxiety over at least what's going on, what's going to happen.
I mean, I can
Who's
see it.
gonna
I'm
protect
sure,
me?
I don't know if, I guess anxiety is kind of a level of what you make of it, like how high it would be. I mean, and what the statute kind of says is constitutional, I find the language, constitutionally cognizable anxiety. And I don't know if it rises to that. I'm sure he had some concern. He had mentioned about it because he had said he had contacted his original attorney, even though that original attorney had told him that this should have been to the public defenders. And he actually didn't file anything until after the notice of appeal actually was finally filed. And those notices that he filed were dismissals and not really an argument for speedy trial. Again, I understand that he is a layman, probably maybe ignorant to the process, but and we cited Ellison in our case that he didn't file the proper motion. And that's the third part through the Wango test or Barker test, which is the assertion of rights. And that didn't come until much later.
So we'll take your argument that his anxiety did not rise to the level of prejudicial anxiety. I think we would be remiss to sort of ignore the other 3 factors in this when speaking to you. There is a delay.
Yes,
You concede that there is a,
absolutely.
Delay.
4 years is a long delay.
and that someone in-
Relative. I'm sorry, didn't mean to cut you off.
No, that's okay. And someone in jail sort of without access to counsel, without easy access to a phone, the ability to look for an attorney, money to pay for an attorney, all of these things and having no idea what is going to happen next. I mean, are you saying that it's his fault that he didn't write to the court sooner and say, hey, what's going on with my case? And then when he did write to the court, he titled it as the wrong kind of brief?
I mean, that is my technical argument, but I do appreciate what you're saying because I understand, like I said, like I just said, he is a layman. I understand he probably doesn't understand the process. We have no verifiable fact that he was contacting Mr. Lee beyond what he had actually said. Mr. Lee was his original attorney that he took the plea with. And so we don't have any verifiable fact. What I would say is, and I know the state takes a lot of.
They did file a notice of appeal.
They did. And I do say that the state does take a lot of responsibility when things like this occur. But a couple of the factors of the time of the 42 months that it took from the notice to when it was actually filed, even though they're all state agencies as the public defenders, I find it hard pressed that 14 months should really be focused just solely on the court or the state. And I think there's, and then we referenced the case within there that those could be considered almost neutral. And not just 14 months, but there was another 5 months applied on top of that, that took for them not only to file, but also then to file a notice. And as much as, we would take the onus on the amount of time, that 19 or so months, as much as maybe doesn't fall on him per se in the prison where he's, in Missouri, but it is on his own counsel for not doing anything. And I can tell you from my perspective, I don't know if I could have called up the public defender's office and said, speed up, find, file this, do this. If I could demand the public defender's office to do stuff, I'd probably tell them not to file as many appeals, but you know what I mean?
So there's nothing you could file with the court to speed along the process?
Not that I could think of. I imagine you're right. I could probably ask the court to ask the public defenders of where they are in the process.
Well, I think it's interesting though, because we're putting an onus on a person who's not an attorney in jail to know exactly what to file, but you said you don't know what to file.
Well, I would make a request is what I would probably do for an answer.
But you understand my.
Oh, absolutely. You got me in a little crosshair there. No,
not intentionally.
But you're right. No, but you're absolutely right.
We do have a prosecutor assigned to the case, right? I mean, that's the one constant.
That is the one
We have a
constant.
prosecutor. And while we do have these agencies that Mr. Hurst is bouncing around amongst, we have a prosecutor who could have filed something with the court to say, we have this appeal on file. It hasn't been docketed, so you could file a motion to dismiss in the district court to dismiss the appeal or do something, right?
Right. Well,
they probably have a list of their cases and it's sitting there and it's on the monthly list they're getting. I mean, they could do something to move it along, couldn't they?
I wish I had that list to tell me what needs to be done because especially like throughout COVID, but granted, you're right. We could have probably asked the court to ask the public defenders to move something along. I do concede that. And that's why I said it's not a complete negligent, it's not a complete negative that it isn't, the onus isn't on the state because it is the defense of the, we could have made that request. I just don't think it should be one of the more huge overlying factors to consider. I think it's more, as the courts have decided before, a more neutral factor of it not moving forward.
Well, Mr. Thompson, isn't there some fault on the district court as well? Because if that appeal is not docketed, there's an obligation to dismiss that appeal. And that doesn't require any action from either party. That's something that the district court can do independently, given their lack of discretion to do that. So there's blame to go all around.
Right. And when that comes back to, again, the defendant, rightfully so, didn't have any fault in that, because there's also a 13-month where the court didn't actually appoint another attorney after the 14 months in which it took the public defenders to file that. So
then when that attorney was appointed, there was a conflict as well.
And then another delay. Right. And so no doubt the 4 years. I mean, but even in Barker, the premise is the facts of the circumstances of the case. The mere passage of time is not determinative. I mean, and I think we all can agree that time passes differently depending what the circumstances might be. I mean, you sit on a hot poker, a second's going to feel like an hour, but if you're having a conversation like this, an hour might feel like a few minutes. Maybe this feels like an hour, but you understand my point. Him sitting in prison, I think you have to take all 4 factors. And I think the factor that's most salient to this, most important factor, is the fact that he wasn't harmed in any way. He wasn't doing anything. He wasn't sitting there pending, wondering what's going to happen. I think you take all those 4 factors. And then when you apply the other 3 factors, and as you say, the time for the delay, and you look at the reasons for the delay. Now, the factors don't fall on the prosecution's office so much, but it does fall on his own personal counsel, which he has no control over beyond trying to reach out to. And I think the evidence that we have is his first time reaching out, at least to the court or anyone, was July 26th of 2019. And so almost a year, 2 years.
I think we should, I don't want to interrupt you too much, but I think sort of placing the blame on him for the delay is probably not the best.
No. And I agree with that.
So
And
you do envision a situation though where a 4-year delay could absolutely prejudice under different circumstances, is what you're saying.
I am saying that, but there's also cases out there, and we cited Wilson, we cited Fitch, and there's a bunch of other cases that say that delay is not a significant delay, depending the other factors. And I believe in this case, the other factors, and again, just like Barker said, you look at a case by case basis. So we have to look at this case specifically. So even with the 4 years, and I completely concede 4 years could be a long time depending the circumstances, but he wasn't out. He wasn't sitting in prison for this specific case. He was sitting for another case. And then you look at the factors of the cause of the delay. And now I'm not trying to escape blame, because again, I agree with you that he probably had no control over it. But then again, some of the onus caused his should-be own counsel that took so long. And I have no idea why they waited so long to find a conflict for them. And I don't know why it took them so long to file a notice. Case law has said those are neutral factors to look at. And I believe that needs to be almost considered as a neutral factor or not an overlying factor, coupled with the fact that, like I said, and I keep repeating because I think it's the strongest argument, is that he wasn't prejudiced in this matter, and cases have seen that before. So I don't have any other issues.
Any other questions?
Thank you so much.
I do want to be fair to my colleague. There were 3 different district court judges due to retirement that touched this case. So that does happen. But I do want to be certain that syllabus paragraph 4 of Boussard-Savarola actually discusses these kind of problems. Neutral reasons such as negligence or overcrowded courts weighs less heavily, but should be considered. Reasons such as lack of funding, briefing ability by court-appointed attorneys, mismanagement of resources by public defender offices are not considered acceptable excuses for inordinate delay. That kind of covers it. The client has a right, and no matter who violates it, that's what happens. I also want to be, like I said, fair to my client. He didn't know he did not have a meritorious appeal argument until I got his case and told him that he does not have a meritorious appeal argument. His lawyer at the district court was arguing that the state should, or the 20-year sentence should not have been consecutive to his other sentence. And so he believed that maybe he'd get that 10 years lopped off on appeal. Now, that would contribute to his anxiety and his uncertainty. And like I said, he didn't know that until I got his case. And in fact, the prior appellate attorney was going to go that direction. I just didn't see it the same way. And, lawyers see things different ways all the time. I saw this to be the strongest argument on this appeal, even though it's not going to benefit, it probably won't benefit him. But the point being, and why I brought this argument up is for other people. If we don't want to make bad law, we don't want to try to do anything with Boussard or Harris, because this is a legitimate problem in our system. People get lost. The appellate defender's office sometimes doesn't get to things, or they don't know they're appointed. And we have people sitting for years that they think they have an appeal and they don't, or nothing's happening. And so I want to make sure that this is more a case about let's make sure that we don't screw this up and change anything because he doesn't have prejudice. Other people would. If he was imprisoned on his own case and he had an appeal pending that he thought he was going to get some relief, absolutely, that would be an absolute prejudice if he was in Kansas and if he was in Kansas on a prison sentence and he had to go back to Missouri, he would certainly also have prejudice, anxiety and uncertainty problems. So I just want to make sure I don't want to give him short change on that, because there is anxiety involved in not knowing what's going to happen. But under these circumstances, it's a little different on the prejudice side. But I don't want, and I don't mean to offend anybody, but I don't want this court to change the fact that the prejudice, while he doesn't have as much as other people, this is a huge problem that needs to be addressed. And just saying that the ADO's office needs to do a better job is not going to do it, which is kind of what they did in Boussard. So, and I'm not trying to bash the ADO's office. They do a lot of work.
We appreciate that.
They do a lot of work, a lot of great work. They're a great resource for other people, but things get dropped and the ball gets dropped between different judges. When you have 3 different judges handling a case, you're going to drop a ball or 2. That's not his fault. So I just want to make sure that's made clear. Like I said, even though his prejudice might be different than other people's, it is there, it is valid, but does it rise to the level that it needs to get some relief, and what's the relief to be had? So nobody's ever decided what relief should be had when there is prejudice. So I guess that's something to be seen later on. Thank you.
Thank you very much. Thank you both. We appreciate your arguments as well as the very clear, great briefing that you both submitted. All right, I think we're ready to call the next case on this morning's docket, case number 124097, in the matter of the marriage of Olufajemi Obembi and Elena Gramatikipulo. Council, can we have your appearances?
May I please support the petitioner, Olufajemi Obembi appears.
Thank you.
And Your Honor, the appellee, Eleni Gramatikipulo, appears by counsel Jim McIntyre.
Thank you. Are you ready to proceed?
Yes, sir.
And Mr. Hull, like, as we said earlier, we are streaming live on YouTube. So if you could have maybe a kind of a summary to orient viewers who may be watching online a little bit about what the case is about. I will not count that into your time. And then I do need to know if you want to preserve any time for rebuttal.
I do, Judge. The request would be to preserve 5 minutes for rebuttal.
I won't start your time until after you finish your kind of factual summary.
Yes, Judge. So this is an appeal from a child support modification judgment in Shawnee County, Kansas, where the petitioner father appellant is the person who pays child support, and the mother is the one who receives it. It's support for the party's 3 children. In this case, both parties are physicians, and their combined income is such that it exceeds the maximum amount of the child support schedules, which have been established by the Kansas child support guidelines. At income levels of that type, a district court is charged to consider the use of the extended income formula and to determine under certain standards how it is, what is the appropriate support amount for children. This appeal concerns the correctness of the district court's decision in that regard, as well as its characterization of the party's payment of certain money into an educational fund that they had established for their children. Your Honor, in cases involving total combined incomes exceeding $15,500 per month, The precedents of this court are clear that the district court must consider the extended income formula and balance several factors to determine the standard of living the child or children in this case would have enjoyed absent parental separation and dissolution, to ensure adequate support for the upbringing of their children, and to avoid the allowance of windfalls. And the argument of the appellant is that the district court sort of failed to do these things in material manners that amount to an abuse of discretion, requiring that this court remand back to the district court for consideration of its application of the extended income formula in a manner that is consistent with the scheme of child support that has been adopted in Kansas, including a serious consideration of the parties' pre-dissolution agreement to pay money into an educational support account. The court's first charge, of course, is to consider the extended income formula. And there's no question that the district court here both considered and utilized the formula, but not to its purposes. And that was a material error on the court's part. It's significant because even judicial discretion of this type is not unlimited. It requires the application of child support guideline principles and an adaptation of the guideline models in a way that result in an equitable award. But a review of the district court's analysis sort of reveals that's not what the district court did at all. Here, the district court was drawn into assuming that father was the only parent with a financial support obligation to the children. And it didn't consider mother's income share in determining how the parties would share in certain of the children's needs as part of its analysis. This is evidenced by the district court erroneously determining that father's current non-educational support amounted to a specific amount per month, as indicated at record volume 1, page 270. Its math had to be that father was basically paying the entire amount for the children's private school, that father was responsible for paying the entire amount of a certain contribution to the children's 529 account, not his proportionate share of those things. And from that math, that sort of incorrect math that is inconsistent with the child support guideline models, the district court determined that the resulting amount available to mother for discretionary spending would have been too low. That error, of course, in this case was invited by mother's arguments and her evidence, which sort of drew the district court into that analysis by suggesting that she had, as a matter of personal budget, sort of paid those amounts from the amounts that are paid to her by father's child support. But analytically speaking, in the exercise of the court's discretion, what is necessary for these children and their needs, that analysis was flawed structurally, and it was inconsistent with the guidelines and itself justifies a remand. But the district court erred in other ways. It erred in its consideration of the standard of living that children would have enjoyed. That wasn't really seriously considered and weighed, and that in at least one material way that can be easily demonstrated. So in the proceedings below, father was really the only source of direct evidence on the topic. He said that there had been no decrease in the children's standard of living since the party separation. But more importantly, there was evidence of the parties' agreement to each contribute money to an educational account for the children, which was the agreement. The evidence of the agreement was that the amounts above the support schedules are what were to be contributed to that account. That was a matter of children's lifestyle pre-dissolution of marriage. The testimony was that account had been around since the party's oldest child was born, and that was the subject of both parties' agreement as to how that money should be utilized. This particular element of the children's pre-dissolution standard of living was what the father argued should be the subject of money in excess of the support schedule, that basically the district court should continue the parties' agreement that amounts in excess of that schedule should be contributed to this educational account. The district court—
Counsel, I thought father was arguing that money should be put in a joint account where he would have to agree, and I mean, setting aside the 529 money, but that he wanted a certain amount set aside, so that mother would have to get his consent in order to spend that child support money.
So that was a sort of, so in the district court proceedings below, the parties had agreed to these educational account contributions.
Right, and that's
Fathers-
kind of a separate issue, right? The 529 was, it's a whole separate paragraph in their separation agreement, and that's separate from the child support and the maintenance, correct?
Certainly mother's position is that it's a separate issue. Father's position is, and sort of has always been, that those amounts that had been contributed to the 529 were calculated based on the application of the extended income formula at the time of the parties' separation, and that it had operated well. Mother had complained that the accounts had been, in her words, bloated. They were very large. They were investment tools, and they've invested well and accumulated money for the children's education. Father's proposal at the time of the hearing was, okay, Judge, let's continue this scheme. If educational needs are adequately met by this account, let's have another joint deposit scheme, an investment tool to be utilized for these excess amounts above the children's day-to-day needs, which would be jointly accessible. And of course, that scheme is entirely consistent with the district court's own family law guidelines at
But counsel, isn't there a method by which the parties can agree to do that?
the parties can agree to do it. And if the problem is, if one party doesn't agree to do it, then the district court is charged to settle the parties' disputes. And here, father's argument was that there's no reason for this particular arrangement not to continue. It is a recognized best practice in the family law community. This court, that is the Shawnee County District Court's own guidelines, direct specifically that the court encourages deposit of funds into trust or joint signature accounts to accumulate funds to be used for the benefit of the child as the parties agree, rather than large payments from one parent to the other. And the district court ignored sort of that mandate and said, you know, I think I'm just going to order a large payment of cash from one party to the other.
Well, counsel, to be fair, I mean, didn't the court's order go through and explain why? It was, I mean, it was not following those permissive guidelines when it set forth and went through the child support worksheet and said, okay, by the time we subtract the 529 account that the mother has to pay, and by the time we subtract the tuition, this is basically what she's got. I think it was maybe $1,400 for the 3 children of discretionary funds.
And that, I think that math was itself error prone because it did not utilize the income shares model of the child support guidelines. So the court says, well, this amount's not nearly enough to permit the deposit of other funds into the joint deposit account. But the court sort of didn't analyze that in a way that I think is consistent with the guidelines model. It was structurally flawed. Secondly, though, the court's decision seems to have been one of policy. So it's disagreeing with its own policy, which our argument is itself an abuse of discretion absent a reason that is fact-based within the case itself that would justify that policy deviation. The reason those guidelines exist is to set out the court's policy so that parties are aware in advance of how a court in a normal case might be inclined to rule.
I just want to clarify.
Yeah.
Right now, we're talking about the 2,000 and 1,000 for the 529.
Yes, Judge.
Okay. And father, maybe I don't want to misstate, I really don't, is saying maybe the 529 isn't the right vehicle for these amounts. Let's consider a different vehicle.
Well, I think the father's position was always 529 has worked well. Like this is an excellent example of why this scheme should continue. It's
Okay.
accumulated money for this need, but he recognizes that the children have other needs and that there are other investment vehicles available, and that the parties should their existing contribution to the 529 could be changed to a new vehicle, like a, I don't know what
Or an
word
IRA or
invests
something.
in.
Why? Okay, so is father requesting that change be made?
He, at the time of the hearing, he did.
And he proposed a particular investment vehicle for that.
No, he proposed that the court order the parties to conciliation or another method of alternative dispute resolution so that they, as parties, could decide the best vehicle for the children. But in order
So
to
is there a
create-
method now, though, where father can petition the court to change the 529? And then if mother disagrees, they would go to conciliation and work that out?
The district court seems to have foreclosed that
Okay,
potential.
so you think that's foreclosed by the district court's order?
The district court's order on the motion to alter or amend indicates, no, you parties seem to be able to work things out. I don't need to order you to go to conciliation on this issue.
The district court doesn't have the authority to make that modification, does it? Modify the vehicle, that's something that the parties have to agree on.
I think that the district court, consistent with the authorities cited in brief, can order the payment of child support by either parent to either parent or even to a third party. In this case, I do think that the district court has that authority. I think that authority exists both within the statutes, but also by virtue of the court's inherent authority to make orders concerning the education and financial support of the children.
But this is something a little more nuanced than that. This is exactly what the parties wanted to do, or what father wanted to do with respect to this 529 investment. He wanted to change the direction of where it's going. I don't think the court, I didn't see anything in the record that gives the court the authority to make that determination for them. That is something that the parties have to agree on what that investment vehicle will be.
I mean, I do think that the district court could tell the parties where to put the money in terms of, and including a trust account. The Marriage of Wilson case is an example of the district court utilizing a trust to hold excess amounts above the EIF. And I know that Professor Elrod in her Kansas Law and Practice series has suggested that it would be easy to have a district court exercise its authority to enter such an order. So I don't have the authority at my fingertips. I know it's in brief somewhere, but I do think that a district court would have the authority to tell the parties that those funds in excess need to be paid to a particular investment vehicle or trust, in not just delegate to the parties. But I do think the better practice would be to delegate it to the parties, because the parties know their money and presumably have invested it well in this 529, and maybe would have a better idea of how to do that for the benefit of the
Counsel, you are into your rebuttal time, but I don't want to cut off question. I mean, I'm happy to just add extra time to the other side if you still have some more questions, because that's why we're here.
I guess I just see it, I don't see this as excess. I see the excess as what Judge Klein was referring to with the $1,400 or whatever that father wanted put in a joint account versus this basket over here that has been specified for a 529. I understand that maybe the court can provide some guidance with this basket of excess money, but I don't think the court has the authority, and please correct me if I'm wrong, to direct them, okay, if you don't want it in a 529, father and mother, then this is where you need to put it. I didn't see anything that allows the court to dictate where that educational fund is going to be, a specific educational fund, not excess from this basket over here.
Sure. So father's position is it's one basket, that both items are support for the children's needs pursuant to a court order, and that they are therefore child support in the same way that, parties can make agreements as to what income is, but that agreement doesn't bind a court. A court is duty bound to independently determine whether or not certain amounts paid for the benefit of children are child support or gifts or whatever classification. So father's position.
529s aren't child support. That 529 is separate and apart from child support based on the agreement of the parties. Those are two distinctly different animals based on the settlement agreement that they entered into.
Now, I think what I just mentioned, it's the same principle, which is that may have been what the parties intended. The parties may have intended to call this basket child support and this basket monetary contributions to the children's educational account. But because this is a court order directing the payment of money toward the children's educational needs, I think this is child support. I think the court retains full jurisdiction over this matter.
So you're saying statutorily, they're both child support. And the fact that one was sort of laid out in a separate section was just an organizational structure in the agreement, as
Yes.
opposed to taking that amount out of child support and saying, there's a child support amount you must pay, and also you must pay educational funds.
That is what I'm saying. And
If it's for the benefit of children,
it's,
then it necessarily falls under this larger umbrella of child support. Anything related to the children necessarily becomes child support.
I think if it fits within the definition of child support, which I mean, there's argument in our brief as to what exactly it sort of defines child support, then it would fall in that category. In this case, I think it is that, because it is a monetary contribution to a specified need of the party's children that is pursuant to a court order.
And
So
I'll say that right now, when the court was sort of saying what parts of the money go to what, there's a private school funding that's being paid, correct?
that's
That
correct.
is coming out of the child support. However, you can use the 529 for the current private school funding, isn't
That's
that
also
correct?
correct.
So the 529 can be spent right now to pay for their private school.
That is also correct.
But that's not what was contemplated by the parties.
Uh,
There's nothing in the record to indicate that's what's contemplated by the parties. When we look at the education based on the child support worksheet under the whatever terminology it used, childcare, whatever, that figure is only the private school amount.
So the party's child support calculation includes payment of the full child support or the full private school tuition. That is correct. So in that sense, the parties did not anticipate that their current payment of private school tuition would need to come from a joint deposit account, because it was already accounted for in the cash payment from father to mother, his proportionate share of that. But there is evidence in the record. There's testimony by Ms. Grammatiki-Polu, Dr. Grammatiki-Polu, where she talks about the purpose of the 529 being the children's education, college, and otherwise.
But
So
it can't be otherwise.
it can be.
Well, there would be tax implications if they don't spend it for education.
Which is why father's proposal to the district court was, okay, if the district court's going to conclude that the children's educational need are sort of super sufficiently met, then those investments that we intended for the support of our children should be directed into a different vehicle that would allow for their spending for non-educational purposes without the tax implications that would compromise the investment tool. The district court instead adopted the sort of two baskets rule, which is, I don't know how to characterize this, but this is not child support. You're just going to continue to pay this $2,000. You're also going to pay $8,170 in cash to mom that she just spends on for whatever purpose, for a total amount cash outlay of $10,000, which father's argument is in excess of even the fullest application of the extended income formula to the party's incomes.
But that was the parties' agreement. Under the settlement agreement, that's how they agreed to divide it. They agreed to child support and they agreed to 529. And now dad wants to come back and put them back in the same basket and say, no, 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 those are both child support.
Well, so the record, I think, establishes that so that agreement was the product of conciliation, and the conciliation record is quoted in brief and indicates that the party's method of calculation was, okay, well, what would dad pay in extended income support at this time? And it was about $3,000 above schedule. So the party's agreement was, okay, dad will pay schedule support plus $1,000 to mom. Mom will contribute $1,000 to this 529 account. Dad will pay an additional $2,000 to the 529 account. So that with that scheme, the parties had effectively agreed that $3,000, that extended income formula would apply, that $3,000 of that, the amount in excess of schedule, would be applied to this 529 account. So while in the drawing out of the parties' property settlement agreement, they're sort of separately characterized, and they may have intended, or the parties may have separately intended, okay, this is support, this is not support. The whole basis of the calculation of those figures was based on the utilization of EIF and the calculation of child support. So I think that this court's needs to consider whether this basket is properly child support. And I think that is a matter not just of party intention, but of its purposes and how the law would characterize those funds.
So I'm so sorry, Judge Klein, we're running over.
Fine. I
Can-
will make sure and give you an equal amount of time.
Can you give us the exact amount that you think is over? Because at the time that the parties made their agreement as to what was being paid, the child support was less than it is now.
Yes.
If we were gonna put these into two baskets, there was a 5,000 dish in child support, 5,000 dish in maintenance, and then this other basket.
Yes.
So what is the exact amount that you think per month the district court is erroneously charging your client?
I think that if the district court, and public math is very scary to me, so.
Yeah, no, I apologize. I was hoping, that's why I'm asking you.
That's why she asked you for the.
Right.
So I think if the court applied the extended income formula, reduced that amount by $2,000 and had dad contribute that $2,000 into this joint investment scheme, that would be consistent with the party's sort of child support scheme at the time of the formation of the property settlement agreement.
So you want to apply EIF in a way that you're saying, which would lower the one amount. Also take the 2,000 and put it into some other vehicle. And right now, if the parties continue to contribute 3,000 a month to these already fairly impressively generous 529s, do you have an estimate of, they would be like $800,000 at the time of college or something?
They would, now I would say college costs are inflating. Both parties
Yes.
are very talented physicians. And so it's.
So I
entirely
assume a
foreseeable.
private school on the East Coast. So I mean, the children could conceivably use $800,000.
Yeah, I think it's possible. Yeah, so I have taken up plenty of your time. If there are any other questions, I'm happy to entertain them.
Thank you.
Honors, I think that one of the fundamental issues that we had before Judge Ludke and that we have now on appeal is the appellant's argument that the monies that went into the college fund accounts should be counted as child support, should be considered as child support. That's apparently how he views it. I can tell you that's not how my client viewed it. That's not how she viewed it at the time of the conciliation. It certainly wasn't how she viewed it at the time of the divorce, nor is it how she viewed it at the time we had our hearing in January of 2021 on this motion. As far as she was concerned, as far as I think the property settlement agreement is concerned, which I drew, those were separate things. Those were separate items. There was a fund that really was being established not to pay everyday expenses for the children, not to pay for the Montessori cost for the private school. It was being saved for college, and the money was going into that for that purpose. Now, I will say, throughout this process, it wasn't she that was insisting that these payments be made. It was the appellant, Dr. Obimbi, who was insisting that these funds be contributed. She agreed to contribute to them, but in no way did she consider these to be child support. And I think her testimony on page 65 of the transcript of the hearing before Judge Ludke makes that clear. What she thought she was getting for child support was the $4,880. That was his child support obligation. Now, out of that, along with her other funds, she had to pay $3,000 a month for the tuition to the private school and another $1,000 a month into this college fund. But to say that his $2,000 that went into the college fund should be deemed child support was not her agreement. And nor do I think that I know that that's not what Judge Ludke determined.
Because child
how he
support is
viewed it.
normally considered support for when they're a child, when they're under
Yes.
18, not when they're college age.
Exactly. And a district court, absent an agreement of the parties, can't order parents to pay for college funds for an adult children. So in our view, this was something separate and apart. It was listed that way in the property settlement agreement. Now, I have seen agreements and have referred to some cases where the child support order says the child support is X number of dollars. And so much of that goes over here into this fund, and the rest of it goes to mother or father, whoever is the primary residential parent. There's a way to write that. I refer to the case of Lask, In re Lask, where that's what they did. And it's pretty clear that it was all child support, and it was intended to all be child support, but some of it was going to be directed to a trust. That's not the case here. That's not the way the property settlement agreement was written. And I might point out, it was Dr. Obimbe's lawyer who prepared the agreed divorce decree. And in the agreed divorce decree, it says that the child support is $4,880. Doesn't say $6,880, of which $2,000 goes here and the rest of it goes to her. I mean, it was very specific. I think the wording of the agreement is clear. I think the intention of the parties was at most at this point a question of fact, which the trial court is to determine. And that determination, if there's substantial competent evidence to support it, is binding on appeal. And I literally think that's what happened in this case. And that the two funds are not the same thing. They're separate. And now there is a process under the agreement to change that. If Dr. Obimbe truly wanted to change those payments, either to it by the amount of the payments or to a different fund for some different purpose, the property settlement agreement said that you can get back into conciliation on non-child support issues. I would submit this is a non-child support issue by sending a certified notice to the other party that you want conciliation on this item. And that didn't happen. He didn't do that. This plan of his to change this from a college fund into a general use fund was something that really was not mentioned to any degree until we got to the trial of this matter. There was no motion filed with the court. There was no certified mail to my client seeking to change the nature of that plan. And again, I think the reason for that is he simply wants to be able to credit $2,000 of payments toward his child support and reduce his child support amount by whatever it is by $2,000 to give him credit for the $2,000 he pays into the college fund. Now, a number of problems from our standpoint exist with that. Number one, she pays $1,000 into those funds. So how is that characterized in the calculation of child support? And that was an issue that Judge Ludke raised before the district court. But secondly, she was in favor of reducing, if not at least temporarily eliminating these contributions into these accounts. These accounts are huge. And I suppose it is possible to spend $800,000, I'm quite sure it is, for a kid's college fund. But these children at the time of the hearing were in kindergarten and second grade. And, you know, two of them had accounts in the neighborhood of $130,000 already. They're more than that now, considerably more than that now. But they were $130,000 for kids finishing second grade. There was a way to resolve this by having an agreement to reduce the amount of those payments. And my client indicated she was willing to do that. But that runs counter to Dr. Obimbe's purpose, which is to control as much of the money that he pays as possible. Yes, he pays $4,880 under the current order, but $1,000 of that goes into an account that he is the primary trustee concerning. And
But why do you say
3,000
1,000 of that? You're talking about the 1,000 that the mom pays toward the education?
Yes.
But that's just mom's month. Mom's supposed to contribute.
That is correct.
So that's not so it's a little disingenuous to say that his child support goes back to him because mom is supposed to pay her own money for the 1,000.
That because that $1,000 did not go into the calculation of the child support. Now, however, the $3,000 that he also insists be paid to the private club or to the private school does go into the calculation of the child support. And he gets credit for that. In other words, if those payments weren't being made, his child support would be different. And he is getting credit toward that child support obligation for those daycare costs or childcare costs. But yes, the contribution to the college fund, the $1,000, it's not
That's
child
school,
support.
though. That's not it's education.
That's correct. That's correct.
Okay, so the $1,000 that mom puts toward the education was not included in the sort of amount that father has to pay in calculating the child support,
It's not on the child support worksheet.
correct?
No,
All right.
no, it is not. It's not on the child support worksheet.
And so with regard to this percentage of amounts that mother is supposed to pay towards the children's care, can you talk about that? I don't want to interrupt your flow, but I want to make sure that we get to the proportionality argument that was raised as well.
Okay. Well, in this case, as in all cases, and I might say Judge Ludke is no stranger to family law. It's all he did for a period of 2 or 3 years when he first was on the bench. And he knows how child support works, and he calculated the child support himself, and his child support worksheet appears in the record at volume 6, page 2. He used the Bradley software, which is a universal program that everybody uses. I don't know anybody that isn't using the same software to calculate child support. It has built into it the shared income approach, the shared income method of calculating child support. So to get to the number he got to, which was $8,170, all of those payments, the payments for his health insurance that he was providing for the children, he got credit for that. And the daycare, childcare expense went into the calculation. And as he pointed out, he even pointed out that his worksheet took into consideration the proportionate contributions that the parties owed to the cost of the daycare expense. She paid all of it, but his percentage of it was factored into the child support. Specifically, what he said was the child support worksheet prepared by the court, which again is the one I'm referring to, accounts for their proportional incomes in their respective contributions to private school tuition. So that's in the equation. That is part of the way that the result of 8,170 was arrived at. Now, I think what the appellant objects to was one way of analyzing what she had and what she didn't have was, and this was the argument I made, and if I invited error, I did, but one way to look at it was if he's paying $8,170 and she has to turn around and pay $1,000 over here at his insistence, that's basically only he wants her to do that. She would prefer not to contribute that $1,000, at least not for a while, to these very large college funds. And if he's going to insist that the children continue to go to the Montessori school where the tuition is $3,000 a month, which she would have preferred not to do. She would prefer to greatly limited that expense.
then that's $4,000 of monthly expense that she has because of his insistence. And so I think what the judge was saying was, if he's to pay $8,170, or better example, $4,880 under the old order, and she has these expenses of $4,000. If you paid it out of that child support, you have $800 and some dollars left over.
Right, but we're agreeing that the $1,000 is not child support. The $1,000 is separately.
That's
It's
correct.
separate. That's what we're arguing. So we'll take that out.
Okay, then you have,
The 3,000, but then she should contribute 27% of the 3,000.
yes,
Right.
yes, she would have that. But we're to the point now where she asked, and then these people negotiated between themselves long and hard about moving these kids out of the Montessori school into the public school that's in their neighborhood. And that is an excellent school. And that was her preference. She had real concerns about how particularly one of the three kids was doing.
So we
In
shouldn't
the
count the
Montessori school.
27% against her because she doesn't want them to be in the Montessori school.
No, but I'm just saying that's one way of looking at it.
Okay.
No, she was ascribed in the calculations of the child support. It would have been 27% of
That's
the
what I
cost
just
of
wanted to
that.
clarify.
Right. And plus, there was a small childcare tax credit that is applied to that because we're considering it as daycare, even though it's not. That was only about $100 a month or a little over $100 a month. But yes, and that all was done in the math. But what I'm saying is that I think Judge Ludke, in terms of analyzing how much money she would have after she paid these expenses toward paying the real direct and indirect expenses for these kids, that was a way of looking at it, a way of considering it. It's not a child support way of looking at it. But to me, it's a common sense way of looking at it. It's kind of, you want me to pay $4,000 a month and you only want to pay me $4,800 and something. That doesn't leave me very much. That's not a child support argument in terms of the calculation of it, Your Honor. I grant you that. But anyway, I think frankly, the argument that the income shares model was ignored to me is not accurate. It's built into the guidelines. It's built into the software that we used, and what the judge used. All our worksheets used that analysis, and that sharing of expenses are based on proportionate incomes.
If I could interrupt you for just a second, the final child support worksheet does show those percentages separated out by amount, specific amount. And the original, the 4880 child support worksheet doesn't show it that way. It just shows fathers at 3,026. So where in that child support worksheet is it apparent that income shares model was followed?
I don't have that one in front of me. But line D2, there should be a line D2 in both of them that would have the proportionate shares of combined income.
I'm sorry, I can't.
That's okay. Can I ask a question while you're looking?
Sure.
I understand the father's argument on the departure from the guidelines. They've raised an issue that the judge should have followed the Shawnee County guidelines and placed a certain amount into a joint account where the parties each had a say in how it was spent. And I understand father's argument to be that the district court's decision to depart from those guidelines was based upon a mistake of fact, and he somehow misunderstood the facts that would support that departure. Can you speak to that argument?
I honestly, I don't know any mistake of fact the Judge Ledke made. In terms of the Shawnee County guidelines, of course, they are policies, but they're not statutes. They're not binding upon the court. I've had plenty of cases where they've chosen to say this is not a guideline case and I'm not going to follow the policies that are set forth in those guidelines. However, again, we're coupled with these additional expenses here, Your Honor, that make what Dr. Obimbi wants to do, which is take everything above the scheduled amount and put it into a trust fund of some kind. That might make some sense under some circumstances, but when you have these fixed expenses that he insists be paid, you don't have that in a normal case. You don't have a normal case where one parent is unwilling to even consider a public school or to consider reducing payments into a college fund. In light of that, that made it very difficult, I think, to cap it off at the top level and use that number. The number Dr. Obimbi was proposing to the court is in Exhibit L, which is in Volume 2, page 85, was $5,419. That was his number. Okay. Again, I understand this is a child support argument with the proportionate shares considered. But if she took that money and paid these $4,000 of expenses that he insists be paid, that leaves $1,400 for everything else. And she's the one obligated to pay the direct and indirect expenses. And that is not sufficient. And capping it at the top level of the child support worksheets where the income, the child support's based on a combined income
Right.
of $15,500. That, I think it would be almost an abuse of discretion to use that in this case, where the combined income of the parties is 5 times that. Where his income alone is 3.5 times that maximum amount. That's just too low for these purposes. It's not enough. Now the court was presented with her budget and her testimony regarding some things that she had deferred, she couldn't pay for. And so there was some evidence of cost of living and things that she was having trouble paying for under the current situation. But I don't know of any mistake of fact he made that maybe I missed that in Mr. Hall's argument.
Well, I can
Yeah.
ask him in rebuttal, but that was my understanding is he's arguing that the court was mistaken about the facts when it made that departure from the guidelines, that he relied on some erroneous assumption with respect to their income. And so I wanted to know if you could explain it to me, but I can also cover that with him as well.
Okay, well, I apologize. I'm not didn't answer that.
So for simplicity's sake, it appears that father wants to make some changes to the 529 vehicle investments and mother wants to make some changes. Yet no one has agreed to go to conciliation to work toward that because a letter wasn't sent or for some other reason. Theoretically, this is under your belief. The district court has not precluded the parties from doing that tomorrow.
No. I don't know how the district court could preclude them. That's built into the property settlement agreement. They both have a contractual right to ask for conciliation over an issue. It hasn't happened to this point. I think what the judge acknowledged was that given her attitude about these college funds and her willingness to even terminate the payments, that there was a lot of room for discussion there about how to deal with it. One of the things that the judge did
Now,
have concern
If we
about,
terminated the payments entirely, though, would that then make sense to reduce the child support by $1,000?
absolutely. Absolutely, yeah. I think it would make sense to reduce, because that's less money that he has to contribute, has to pay.
And, okay. But when you think of it like that, then he's paying $3,000 a month for the 529s, as opposed to
Well-
her paying 1,000 and him paying 2,000.
I'm sorry, I have misspoken.
Okay,
Because the $2,000 I don't consider as child support. I'm arguing is not child support.
but the 1,000 she pays into the 529 is child support.
No, it's not either, really.
Okay.
I don't think it's a child support.
So if we got rid of all of the 529 payments, your position would be that he would still make the exact same child support payment to her.
Yes, it does not affect that worksheet that Judge Ledke did.
Okay.
The thing that would affect it is the amount of the schooling cost, the daycare cost.
It would just increase the discretionary amount by $1,000.
Well, if you did away with, well, yes, it would help her in terms of she wouldn't have $1,000 that she had to pay, but it doesn't affect the child support. The thing that would affect
Then
it,
sort of calculating that into the child support, saying that she actually doesn't have that much child support because she pays this $1,000 into the 529. But then if we got rid of the $1,000, there'd still be the same amount of child support to pay.
it wouldn't affect the calculation on the Bradley software. What would affect it is if they took the children out and put them in public school, they would still have.
Well, I don't
Their
think we're
expense
discussing,
going
I
out.
don't think that's on the table for us to, we're not working.
But
on
my
that.
point is it would change the math. That would change the math.
The $1,000, she just chooses to do what she wants to with that $1,000 from the child support. It's not designated as necessarily needs to go to the 529. She just chooses to take the $1,000 from her child support to put into that 529 account. So if that 529 no longer existed, she could, that $1,000 would then be opened up to her. It would remain, and she would then have that unencumbered fund to deal with.
Yes,
But it doesn't affect child
it
support.
would be $1,000 less in obligations that she has to pay out of her income,
Yes,
her assets.
correct.
Yes.
Any other questions?
Thank you.
So
Still 5 minutes of rebuttal because I made sure and give the other side equal time, just to give you an idea. So you don't feel like you have to hurry up and rush.
we have a lot to cover. So the first rebuttal issue is, well, what is child support? And I think the discussion with Mr. McIntyre demonstrates how difficult that question is, because it seems that Mr. McIntyre recognizes that the additional $1,000 above schedule support that Dr. Obembe pays to Dr. Gramatiki Polu is then utilized to deposit into the 529 account. So, and there's no question that additional $1,000 is on the child support worksheet. But he wants to say at the same time that the $2,000 that was the basis of the same calculation that led to $1,000 being deposited, credited as child support, is not child support, even though it goes to the exact same repository.
Where's the $1,000 on the worksheet?
It's so if the court looks at the initial worksheet, the 4,880.
I'm talking about the one that you appealed, the one at issue today.
The additional 1,000 is built, it would be built into our worksheet. And there were a number of demonstrative exhibits. I recognize that our request was the more complicated request of the district court below that demonstrated that here's your schedule support amount in concentric Venn diagram. I want to say it's like exhibit O or.
No, I've seen your exhibits, but I'm talking about the child support worksheet that the district court used to calculate the child support. I didn't see the $1,000 in there. Am I missing that?
No, the district court used full yoke EIF and said, this amount is the correct amount of child support, pay this amount
Right.
plus the additional amounts that you've separately agreed to. What I'm saying is the record substantiates that the party's initial calculation of child support was that dad would pay scheduled child support plus $3,000. And instead of dad paying the $3,000 to mom and requiring that she pay it into the 529, which was an option for the parties, in which case this dispute wouldn't exist because I think it would be conceded that was child support. Dad did a hybrid and the parties agreed to a hybrid where dad pays mom $1,000, mom puts the $1,000 in the account. Dad takes $2,000 of his own dollars and puts the $2,000 in the account. And so for that reason, I mean, I think that just further supports the idea that the whole thing is child support, and it would seem unimportant. And I think the law supports the idea it's unimportant to whom it's paid. The question is its purposes of payment.
But I guess,
Oh, sorry.
no, you go ahead.
Well, I mean, the 529 money is not used to support the children when they're minors, correct? I mean, the parties aren't using it in that way.
It can be. They
Can
are
be, but they're not. They're not. And so child support normally is considered, as we discussed with your counterpart, as support for the children when they're minors, because the court can't even order the parties to pay for support for their children once they reach 18, or, I mean, they can't order them to pay for their college.
So I don't know.
That's my hang up.
True necessarily, at least in my reading of the pre-guidelines case of Marriage of Allison, but in the Shawnee County guidelines at 6.3b discussing these sort of joint deposit accounts encouraged by that court, the final sentence about those accounts is examples of how these funds can be used are for college, purchase of automobiles, educational trips, and other major expenses benefiting the child. So at least
Those are discretionary guidelines. It doesn't give the court authority, even outside Shawnee County necessarily, then to order the parties to pay for college.
no, I agree. The local guidelines don't give additional authority to the district court to enter orders concerning payment of college.
I'm not talking about additional authority. I'm talking about any authority.
No,
Does the district court have authority to order the parties to pay for the children's college?
as I read Marriage of Allison, that is, I think it's consistent with that, but that's a pre-guidelines case.
Right.
And because I've not briefed that issue, I don't know that I have a good answer for you, Rana.
And here, in this case, the parties are not using the 529 money to support the children currently. It is earmarked for college, correct?
I think that the parties, and specifically mother, recognizes her ability to utilize those funds for the payment of college or otherwise. I think that's supported by her testimony in the record.
But you cannot use it for college or otherwise. That has to be used for education.
I'm sorry, you're saying or other education.
Or other educational purposes that are not college. And again, I am not an expert on the Internal Revenue Code either, but as I read the Internal Revenue Code, it permits the use of those funds for non-college educational purposes under the age of 18.
It does, but they're not doing that here. They have a set amount of money that they are using for that, so that it's not even contemplated by the parties at this point that they would use it for that. That's never been argued.
Because of mother's testimony at the time of the hearing, she said that those funds are educational for college and otherwise, suggesting to me that she appreciates that they can be used for purposes other than educational needs, other than the college needs of the party's children.
But the fathers never asked for that to happen. Correct. I mean, I haven't seen that in the record. Did I miss that?
No, but because the parties have separately added the present private school tuition costs to the child support calculation, and they've not parceled that out. So properly, I think father could say, well, tuition and fees need to come from the 529 because that's not work-related childcare. He has just chosen not to do that. So that order is already super sufficient for its purpose, which is to fund those needs, because educational needs are supposed to be automatically built into the guidelines calculations. And his position has just been, I'm not going to debate that. I'm happy to give my contribution to the full amount, even if it's duplicative of some other child support amount, which is calculated using EIF or otherwise. So that's issue one. I think our position is clear. I think that position is well stated in our brief, and I don't think I can better state it here. But two is this error by failing to follow the income shares model. And in listening to the arguments of Mr. McIntyre, we're not alleging or arguing that there was a structural error in the calculation of the support figure. That's not what's claimed. Instead, it's a structural error in the discretionary analysis by the court as to the application of EIF. That's what's claimed. And I think
What's the error? What's the factual error you're claiming that the district court made?
so. There's two. They're at record volume 1, page 273. These are just the factual errors. So there are sort of two full paragraphs there. In the first full paragraph, the first claimed error is that the court is talking about mother's monthly budget. Father's counsel cross-examined her on these expenditures, demonstrating a number of her budgetary expenditures were marginally related to the children. However, the fact remains that no matter how her $16,500 per month is budgeted, under the existing child support, father currently contributes $854 per month for the non-educational needs of the 3 children. That calculation, as demonstrated in brief, is structurally inconsistent with the income shares model. Then again, in the second paragraph on that page, in discussing the placement of funds into a joint deposit account, the court finds a joint account arrangement would leave father's contribution to the day-to-day discretionary spending at $1,393 per month. Under his proposal, again, the result of a structural error in the way that the court analyzed the amount of money that would be available to mother under its calculation of support. So while it's true that in between those two errors, the court says the child support worksheet prepared by the court accounts for proportional incomes and respective contributions to private school tuition, when it was suggesting, hey, Dad, if you want a lower support, just put your kids in public school. That there's no question that the worksheet was correctly prepared and that Bradley software was functioning. The problem is the court, in deciding how much money was necessary to give to mom, its critical exercise of discretion was burdened by what was mother's argument and what it adopted in its analysis to say, okay, well, this amount that you pay for private school, this amount that you contribute to the 529, we'll just remove those, not your proportionate shares of those, not father's proportionate shares of those. We'll remove the whole amounts and
By
we'll see what's left.
including the $1,000 that mother is supposed to spend above and beyond, which if father is spending 2,000 above and beyond, mother spending 1,000, by including that subtraction in saying that there's only this much discretionary left, then because we're not calculating the 2,000 we're not giving father credit for the 2,000.
Well, yes, that's correct.
So then by including the 1,000, you're saying that that's an error.
The 1,000 and the amount.
27% of the private school.
Well, the court just subtracted the entire private school tuition from the amount dad pays, as well as the 1,000 mom pays for the 529 contributions, without consideration of, well, actually, I guess that some of that should have come from mom's own budgetary expenditure, her funds, not the child support funds. Those errors in structure were significant. And I think that the mathematical differences are significant. And it's not clear at all that the court considered that those differences existed. And it's especially important because the charge of the district court in determining how far into EIF to go is to avoid creating a windfall for one party. For a windfall, father would suggest would be something like taking away $1,000 of a direct expense mom currently pays and still paying her the same child support amount. That's a windfall because the need doesn't exist.
And counsel, you have moved beyond your rebuttal time. So I wanted to give you some time to wrap it up or make sure. Do we have any other questions?
I do not.
Before you moved on, if you want to take 30 seconds to wrap up, I can certainly give you that.
Yes. So the last thing I would mention is windfall. The court was duty bound to avoid windfall, and the evidence of windfall, I think, is clear in its analysis, because it doesn't really point to specific needs on the part of the children, but sort of it makes aspirational statements as to what mom sort of would wish to do with additional funds. And mom's testimony made it clear that even in her view, some of her personal needs estimated tax payments on her income, her personal health insurance, her charitable contributions were properly inuring to the benefit of the children, and so would be the proper subject of a child support order. And because Kansas distinguishes between maintenance and child support, and because the district court was without authority to enter an additional maintenance order for spousal maintenance, to the extent that it sort of indulged that testimony, that analysis, and didn't identify, not necessarily shown needs, but appropriately modeled, economically modeled needs, or sort of natural needs of the children, I think that it operated beyond the authority granted to it by the legislature.
Thank you, counsel. Thank you both for your arguments and your excellent briefing. We'll take the matter under advisement and issue a decision as soon as possible.